Can you hear me? Hello. As you'll see from the name indicated, it's showing Amy Glover as your speaker. For those of you that may know Amy, you'll probably realise that I'm not her, but actually Mark Farrell, who is the head of trust for Butterfield Trust Asia Limited in Singapore. So at Butterfield Trust, we deal with the administration and trusteeship of a number of trusts. And I will now be going through the subject of protection, growth, and the transfer of wealth through trust services. I'll be splitting this into three segments. The first will be dealing with the value of creating a trust. The second will be dealing with the types of assets that you may hold under a trust. And then a brief section on the types of trusts that you generally see from an offshore context. So starting off with the value of creating a trust, there are, again, various subjects here that I will go through, looking at family succession, probate, asset protection, political and economic uncertainty, which obviously is something that lots of us are looking at now, having family members in different jurisdictions, and the continuity of investments. So perhaps starting off with one of the major reasons that an individual may consider setting up a trust and looking at passing assets to the next generation, this would be family succession. So here you would look in two aspects. One is from a settlor perspective, so that's the individual who may create the trust. And secondly, from the beneficiary's perspective, so those will be the individuals who are able to benefit under the terms of the trust. So from a settlor's perspective, individuals would obviously create a trust taking into mind potential issues that they may occur later in life. So one of these would be incapacity. So from a settlor's perspective, assets transferred into the trust may be used for their benefit during any period of incapacity where the trustees may be able to pay and apply assets under the trust for medical expenses, taking care of them in their home, paying for help at home, etc. It may also be able to assist the other family members to take care of themselves during the settlor's incapacity also. The family succession, again, would look at the way the trust is able to make distributions to a beneficiary. So this may allow a staggered distribution rather than a lump sum, which you may see under a will. And it would also take account into different circumstances that may arise during a beneficiary. So for divorce, for bankruptcy, etc., and to take care of minors and guardians. A trust is also able to provide for beneficiaries that may not currently exist. So this is where there may be grandchildren that appear later on, or other scenarios. Again, educational needs, medical needs, and emergencies may be taken care of, together with charitable needs that may arise for particular families. Some trusts, obviously, or all trusts will deal with flexibility, so these will be allowing for change depending on families and how they change over the years. So for an example, a settlor may create a trust bearing in mind that he has children and grandchildren of a certain age now, but over the years, as these people get older and as they may move to other jurisdictions, which I will cover later, these circumstances may change and there would need to be flexibility in the trust. So again, a well-drafted discretionary trust deed will allow for this to happen. Also, you will look at ensuring family harmony and being transparent, perhaps, in the way that you plan. So the idea of a trust is perhaps to bring together a family either through consultations, through committees, to allow a family harmony when those assets pass. You do see many cases, for example, some high-profile Hong Kong families, where there has been perhaps a lack of transparency or no trust provided for at all, where there are disputes. And this can obviously lead to much dissatisfaction within a family and protracted issues within court and excessive costs. Passing on to probate, there would be the scenario that where an individual does not have a trust and they pass away, then there would need to be probate granted for their estate. So this would be either where they have a will or don't have a will, and maybe letters of administration or something similar may be needed. Obviously, when probate is required, assets are generally frozen within a country. So this would be, if there is a bank account that will be frozen, nobody has access to that. So there may be difficulty in families providing for their day-to-day needs or for emergencies that maybe arise, and the payment of tax liabilities that could be due on death. Probate is also very time-consuming, particularly where you have individuals who have assets in multiple jurisdictions, because probate may be needed, for example, in Singapore, in Hong Kong, Malaysia, other jurisdictions. And all of these processes do take time and the costs can be quite high depending on the number of applications that may be made. And the reason, again, for looking at this from a trust perspective, that anything held under the trust does not require probate, because the trust and the underlying company, if there is one, will be continuing entities. So the passing of an individual would actually, whilst being sad for the family, would actually allow for continued access to assets and the management of those assets. So probate really, together with family succession, are two of the key reasons that individuals would cause trust to be created. It would also mean that the assets are not disposed of untimely. So perhaps there wouldn't be a fire sale of specific bankable assets if the markets are low, the sale of real estate to raise cash to provide for expenses. A trust, again, as it would hold assets from a continuing point of view, would be able to provide for these requirements as needed. So really, looking at probate, it's one of the key considerations to ensure that there are sufficient funds available to families, looking at the untimely disposal of assets, cost and time on actually the probate application itself, limiting misunderstanding between family members, because again, as I mentioned earlier, you look at transparency in perhaps providing for a trust, and really looking at assets not being frozen at that time. Passing on to family members in different jurisdictions, as we are aware now, many families live all over the world. So you could have, from a Singapore perspective, a settlor living in Singapore, a family member living in the US, another one in the UK, another one in Australia. Looking at all of these different jurisdictions, there are obviously different taxations that apply, different ways a family may live, and different laws. So again, having a trust can cater for these scenarios to a great extent, whether having a single trust for a family living, say, in the US, another one for somebody living in the UK, depending on the regime that then applies. So again, looking at family members, you can also look at different assets in different jurisdictions. So again, you may have real estate in the UK, real estate in the US, you may have bankable assets in the US, and with families now, they may have operating companies, again, in many jurisdictions. So a trust would be able to cater for these. It will also allow for the smooth cross-border transfer to the family in times of need. So again, looking at a movement of a family, let's say that the child is currently studying in the US, then moves back to Singapore, then decides to go and work in the UK, you can look to cater for these scenarios, again, under a trust scenario, which is very difficult under a will. Another issue would be asset protection. So here we look at how assets are protected for the family's benefit in the future. So this may be from a settlor's point of view in the event that there may be a divorce. In regard to the children's benefit, again, if they are beneficiaries for divorce, for bankruptcy, for the ring fencing of assets, and to avoid the adverse consequences of immediate wealth transfer. So this could be an example where you have an individual who has a younger family, maybe children going to school, maybe going to university, and they don't want the child to receive assets too much at too young an age. So this is particularly seen where you have, from my personal experience, a family receiving large amounts of assets and being given to somebody who may be in their 20s. I've seen many families where the child may have undue influence exercised over them, they may be susceptible to other issues and go down a path which is not envisaged by the family. So this could be that they go down a route of taking drugs, giving away money, etc. The way the trust would work, and again, contrasting to a will in a moment, the trust would allow flexibility in the way that the assets are passed over to the individual. So as I mentioned earlier, you could consider giving a lump sum to an individual, or you could stagger giving, let's say, $10,000 to an individual per month. This would mean that where you have an individual who is subject to undue influence, they don't have a large amount of money in hand which they are able to dissipate. And where you have an individual who may be subject to drugs or to alcohol or to other vices, it would mean that the amount of money that they have is limited, so that you're able to encourage that individual to go down the path of maybe going to university, starting a first job and working. Where an individual plans badly, it could lead to adverse consequences, as I mentioned. And I have seen a number of families where they haven't planned, and children, unfortunately, have led lives which is not productive as far as the family are concerned. So asset protection in its various forms is actually quite key in, one, looking at the asset protection of the particular asset and looking at the protection of a family member in due course, particularly when they are young or when they are vulnerable. So trusts really do act in a way to ring fence assets for vulnerable individuals. And it could be that the settlor decides that during their lifetime, they are the one to give guidance. But as mentioned earlier, as time passes, situations change, and a settlor may want individuals to act as a committee to advise the trustees. So you could have a protector committee, or you could have more of an informal committee, maybe other siblings of a beneficiary, to advise the trustees on how things are to work. So looking from an asset protection point of view, it's really looking at assets, and again, I would look at the protection of individual beneficiaries who may be young, maybe minors, or may be vulnerable to undue influence or other issues. And again, as I said earlier, divorce is one of these things where we see many families having an issue of divorce, and where a trust is established, this may provide a lot of protection, particularly on the second or third generation of beneficiaries from a divorce perspective. Going on to political and economic uncertainty, as we know, the world is going through a lot of change at the moment, and where there are potential political events and economic turbulence happening, it makes a structuring a much more pressing need for individuals to be able to insulate their assets from these uncertainties. So again, this was highlighted during COVID, where we saw many individuals considering their succession planning needs, considering how probate was going to impact them, and considering how they would like to look to structure. Some individuals may decide that a will is sufficient for their needs, if their estate may be quite simple with just a bank account. But again, as mentioned, probate does take time and may be costly, and where you have a family who may be slightly, let me say, different, in that there could be a wife, there could be a mistress, there could be children from different marriages, probate may lead to arguments and uncertainty on how an individual's assets will pass, and there may be challenges at court. So establishing a more robust structuring would be more sensible, and again, this is where a trust would kick in. So going back to political and economic uncertainty, this is really quite pressing, and clients should consider how they structure their wealth, particularly where they have it in jurisdictions that may be not as stable, and they would like to consider placing those assets into jurisdictions that are much more stable. So being in Singapore, Singapore is an extremely stable jurisdiction with a very good governance of law, very well regulated with MAS. So it's a jurisdiction where we see many clients actually considering to establish trusts, particularly obviously as they have banking relationships within Singapore. Another issue that you see with clients in some jurisdictions is the risk of extortion and blackmail. So this is particularly where you have a client who may be slightly understated, and they are at risk if their wealth is made public. So there have been clients that I have known where family members have been kidnapped, and they wish to ensure that their wealth is actually ring-fenced to a much greater extent by placing those assets under a structure. So that the knowledge of those assets in the wider regime is not known, particularly where you have a real estate which may be on a public register, or you have listed shares, lots of central listed shares which are may again potentially be disclosed, or you have operating businesses again which can be disclosed. So holding these assets through a structure provides a confidentiality from extortion and particularly blackmail of clients and kidnap as well. So again, these risks are more prevalent for families who live in certain jurisdictions and are something that we do have conversations with clients in relation to the establishment of a trust. So looking at another aspect, which is continuity of investment, This is really where you have clients who have certain asset classes that they may wish to place under trust, particularly shares in listed companies or substantial shares in listed companies and operating companies, family operating companies, where the client wants those assets to be managed in the long term by their descendants. So a trust would allow those assets to remain under a single structure. There isn't any dissipation of those assets leaking out through the structure to family members, so you have a wide number of individuals who own and manage those assets. And it would allow the smooth succession of those assets to family members, or the income of those assets to be passed out. What I mean by that is, if you have, say, an operating company that is generating profits, you're able to use those profits and distribute those profits out to a family member rather than distributing the actual shares out to the family member. So it will allow the asset, the family operating company or the substantial listed shareholding, to continue to be held by a vehicle, so a trust, for many, many years. So dealing with the voting rights and perhaps allowing family members to sit on the board of that family company, whilst allowing profits to be used by family members and dissipated out to family members. So again, it's a way of really preserving an asset from the long term. When you're looking at a bank account, again, trusts typically will have a reserve power, which will allow a family member or the settlor to manage the investment portfolio during their lifetime. In the event of the passing of that individual, there may be the powers under the trust to allow other individuals to manage the investment portfolio thereafter. So again, it would allow really the involvement of the family in the management of the assets that are held under the trust. So it's really looking at the way, although the assets are held by a trustee, it's looking at family involvement in those assets and the management of those assets by the family. So recapping on the value of creating a trust, it's really looking, as I said, at family succession, so allowing a smooth passing of assets to families over a staggered period or immediately on death to cater for immediate needs that the family may have. For younger family members to look at the way that their life is not adversely affected by the inheritance of an immediate or a large sum of wealth. To allow for minors, to allow for unborn beneficiaries, to also allow for distributions for educational, medical and emergency needs, perhaps to bring in charitable aspects that a family may wish, to deal with incapacity whilst the settlor is alive and may have issues later in life, and to ensure really a harmonious family through the distribution of wealth later on, and being as transparent as possible for a settlor during their lifetime. Bringing in, as I said, families who live in different jurisdictions. This is to allow for a flexible approach for families who may live in one jurisdiction, move to another, children may study somewhere else, and also assets may be held in multiple jurisdictions where different taxation regimes may apply. Looking again at asset protection, as I said, that's looking at divorce, bankruptcy, of particularly the second generation. Looking at the ring fencing of assets under a trust, which after a period of time may not be subject to creditor claims. And then also looking at where assets may be located to ensure tax efficiency in the way that you may structure. Political and economic uncertainty, again, I mentioned, particularly with the events that we have today, and looking to place assets in a stable jurisdiction for succession planning purposes, and whilst allowing the family members to manage those assets on a long-term basis. Another reason, again, will be to look at the risk of travel. So where individuals are travelling together, there may be an untimely occurrence of many family members passing away at the same time, which I have encountered, and allowing for a trust to continue holding those assets. When you contrast this again against a will and where an individual may hold assets in personal names, although there would be family succession, this generally tends to be fixed under the terms of the will and doesn't allow the executors the same flexibility that a trust would allow. And also from a family protection point of view, under a will, there would be generally an immediate inheritance. So if an individual may be going through a divorce, if there is a claim for bankruptcy or a creditor claim made against an individual, you could see assets being lost through that because there would be an immediate inheritance by an individual following the probate application. And as I said, the probate application does take a great deal of time generally to go through. I realise I've gone through the reasons for creating a trust rather swiftly, so if there are any questions later on, please do feel free to ask. I'll now pass on to the types of assets that an individual may consider holding under a trust. So typically you would see a bank account being held under a trust, so this would be a portfolio with a private bank, or portfolios of many private banks in different jurisdictions. So typically at Butterfield we would hold assets of private banks in Singapore, in Hong Kong, maybe in Switzerland. There would also be insurance policies. So this would be rather than an individual holding the insurance policy and then this may be paying out into their estate, the insurance policy would pay into the trust, and then the trustees would use the insurance policy for the benefit of the family. So this could be for the immediate payment of a tax liability where that arises, or for giving lump sum payments to individuals on the death of the settlor. As I mentioned, there are trusts that would hold substantial shareholdings of listed companies. So at Butterfield, we hold these in substantial shareholdings in Singapore, in Hong Kong, looking at Thailand and other jurisdictions throughout the region, and obviously in the US. There is a lot of pre-IPO planning where an individual may hold shares in a private company. They place that private company under trust, and then the private company would list. And thereafter, the trust would hold those listed shares. But the trust would hold the pre-IPO company during the listing period. So this could be, say, from 3 months to a year. Trust would also hold shares in family businesses. So this would be an operating company that the family has in Singapore or in another jurisdiction. Also quite popular now would be the family office. So this was the 13X and 13R, which have been renamed to 13U&O. Where a family may be looking to move into Singapore, they would set up a family office to hold their bank accounts here, and then the trust structure would hold those assets, and then either the family office itself or the resulting bank account, and there will be an arrangement where this is managed. So again, this is very popular in Singapore for families moving into Singapore, or also Singaporean families that are already here. There are also chattels that could be held, so this could be art, it could be antiques, cars, wine collections. There could also be aircraft, there could be yachts, again, a popular asset that could be held under trusts. Real estate can also be held, so this could be residential real estate, commercial real estate. Generally here, a trustee would look at foreign ownership restrictions, so again, there may be some issues where a foreigner, being a trustee based in Singapore or an underlying BVI company, being foreign to the jurisdiction where the real estate is held, may not be able to hold. So again, we would need to look at that. So again, the idea of the trust is it's very flexible on the nature of assets that it would hold. So it would allow the transfer of these assets from the settlor into the trust, and then the passing of those assets later on to the family member. The growth of those assets would be within the trust itself, and the trustees would hold those assets and protect those assets for the future generations, which is key and one of the main reasons that the trust will be set up. So together with the value of creating a trust and the types of assets that are held in the trust, settlors see this as a great advantage for using Singapore as a jurisdiction for establishing a vehicle. Going on to the types of trusts that are created, these are really two types of trusts, with one being much more prevalent than the other. So from an offshore context, discretionary trusts tend to be created, so these can either be revocable or irrevocable. A revocable trust is one whereby the settlor is able to cancel the trust during their lifetime while they have capacity. An irrevocable trust is one where they are able to do that. You do see a mixture of both types of trusts being set up, and there are different reasons that settlors may choose to do this. It could be from a taxation reason, it could be from a control reason, and again, it could be that a trust is set up as a revocable trust at the outset, and then it may become an irrevocable trust later on. So Trusts generally would have a letter of wishes that would give guidance to the trustee. So this is a document whereby the settlor will say that maybe the trust assets can be used for their benefit during the lifetime. In the event of their incapacity or passing, then it would indicate how those trust assets are to pass. So it may be that the assets are to pass to their family members in a lump sum, as I mentioned earlier. It may be that they are to pass income or a fixed amount to a beneficiary during a certain period with distributions of lump sum thereafter. So as I said, it could be that a individual can receive, say, $10,000 a month during their lifetime, and maybe when they attain 30 or 35, they receive a capital amount from the trust. And the letter of wishes generally will give flexibility so that in the event of a change of circumstance, so that an individual may move to a different jurisdiction, they may suffer a divorce or incapacity or have another issue during their lifetime, the idea of the trust is that it's very flexible and can take account of that. So as I said, that it can protect the individual from any circumstances that they may face, and it can also allow the smooth transfer of assets to the individual during their lifetime. So letters of wishes can be very simple in the way that a settlor may choose to pass the assets on to a family member, or they can be much more complex in the way that they work, particularly when you have different types of assets, particularly a family business, where a settlor wishes to put family governance in place to involve certain family members in the way that the business runs and the way profits are distributed from that business to families. Lastly, I would come on to the types of trusteeship that there may be. So at Butterfield, we are a corporate trustee, so we generally act as trustee of the trust. And as said, we would have reserve powers giving out to a settlor to deal with investment management. The settlor may also perhaps act as a protector of the trust so that they may have consent powers over the trust. Some settlors and families may prefer a greater element of control over the trust, so they could consider setting up a private trust company, whereby this is a trust, whereby basically the family act as a trustee of the trust. So rather than the decisions and administration of the trust perhaps vesting in the corporate trustee, so Butterfield, it may be that the decisions would vest in the family acting as directors of the private trust company. So again, you see private trust companies set up for families who may want to place an operating company into a trust where they would like to have more control, or they have substantial shares in listed companies, again, where they may like to exercise more control in terms of the way decisions are made in relation to that underlying company. So again, that's something that many clients do consider, and we at Butterfield do deal with the establishment and running of private trust companies where we act as administrator of the trust, as is required under the rules of MAS here in Singapore. So I know I have a 30-minute slot followed by questions, so I have run through these subject matters quite quickly. So again, just to recap, the value of creating a trust really will be to look at family succession, the probate issues that may arise, and contrasting how that is dealt with under a trust and under a will, looking at political and economic uncertainty, looking at asset protection, looking at family succession, looking at the ability for the family to manage and continue involvement in the trust and the underlying investments, looking at the various types of assets that may be established maybe placed under a trust, being bankable assets, insurance, listed shares, family business, family office, and art, antiques and real estate, and the types of trusts. So I'd end the presentation there, and I'd now go on to questions that may arise. So there is a question on how do you deal with the duration of a trust, and is it set up in perpetuity? So trusts are set up under different proper laws. So it may be in Singapore, we have a trust under Singapore law. There could be a trust set up under Jersey law, Guernsey law, and Cayman law. Each of the jurisdictions would have a perpetuity period under their proper law. So in Singapore, we have a perpetuity period of 100 years. In other jurisdictions, there may be a trust that's set up with an open-ended perpetuity period, or there could be a trust that has a 250-year perpetuity period. So broadly, in Singapore, if there is a trust that's set up with a perpetuity period of 100 years, at the expiry of that perpetuity period, then there would be a requirement for the trust to end and the assets to pass out to the beneficiaries. So if you have a family where the intention would be that the settlor creates the trust, the idea is that the assets of that trust pass to the children, let's say by the time they're 50, and the assets are then to be distributed. And in the event that one of the children has passed away, the grandchildren would get the assets again, let's say at the age of 25. A Singapore law trust would work extremely well because it would be very unlikely that the 100-year perpetuity period would be exceeded. If, however, a client wishes to establish a trust to hold a family business, and the intention is for the trust to hold that family business indefinitely, then you may want that trust established under the proper law of a different jurisdiction. But in Singapore, obviously, we are able to act as trustee of trusts with an open-ended perpetuity period. So we can act as trustee of a Bahamian law trust, a Jersey or Guernsey law trust. So again, we would consult clients and look at the assets that they wish to place under the trust, the rationale of why they are settling a trust, and then consider the perpetuity period that may be applicable. Another question is, does the letter of wishes not fetter the discretion of the trustee? So here, the way the discretion, there are two types of trusts. So I didn't go into the second type of trust a great deal, so I'll just cover that now. You have a discretionary trust, which basically is a trust whereby the trustees are able to pay and apply the capital of the trust to any of the beneficiaries when they may wish, and the letter of wishes would give guidance. The second type of trust is a fixed interest trust, where the trust would give a beneficiary an absolute entitlement to assets. So this may be a capital entitlement or an income entitlement. You see this occasionally, but not so often. Then with a discretionary trust, which is the more prevalent type, there is a letter of wishes which would give the trustees guidance. So the letter of wishes is something that can be changed. And as I said, the key word is it gives guidance. It's not a document that is fixed, and it would allow the trustees and the discretion to review the letter of wishes and apply the terms of the letter of wishes. So it's very flexible in its approach. So the way the letter of wishes is written is quite crucial in that it would indicate that the settlor gives guidance to the trustees and an indication of how they would like the assets to pass. It doesn't say that the trustees must follow the letter of wishes, but it gives guidance. So again, it's something that really is quite key on the way a letter of wishes is drafted to ensure that it gives the flexibility of allowing a distribution to beneficiaries without giving any beneficiaries an outright entitlement to assets. So you would typically see a letter of wishes drafted to say that during the lifetime of a settlor, the trustees may wish to consider them being a principal beneficiary, but also during their lifetime, the wishes and views of other beneficiaries are to be taken into account, particularly in the event that an emergency may arise. And then on the passing of a settlor, it may be that the letter of wishes gives an indication of assets being distributed to a beneficiary at certain times and in certain amounts. But again, the key is that it would be guidance. So as I said, the letter of wishes is able to take into account adverse situations that a beneficiary may find themselves in, particularly in times of divorce, in times of bankruptcy, or if the life of a beneficiary doesn't turn out in the way that a settlor would originally envisage. So a beneficiary may be subject to undue influence, the beneficiary may be subject to issues over drugs, etc. So I have seen clients where a trust has been established and the beneficiary's direction in life has changed, particularly in relation to drugs. So the idea is that the trustees would pay for medical expenses, so rehabilitation, sending the beneficiary to hospital on courses perhaps to assist them. The trust would own their property, would give them a right of occupation of the property so they're not able to actually get a property and sell it. And then maybe the trustees would pay for their living expenses to a certain extent and give them a weekly allowance so that they don't actually have too much money in their control. And then the settlor or the trustees would take guidance from other family members who may be on the ground in the jurisdiction where the beneficiary lives to give guidance on how the beneficiary is developing and how they their life may be progressing. I've also requested beneficiaries to take drug tests and go to a hospital and get tests to see if whether they are on drugs before distributions are being made, to see whether we will make a distribution to a beneficiary. So again, as a trustee, you are able to step into the shoes of the family in the way that you would deal with distributions to trusts, to the beneficiary. So this is really looking at the protection of both assets within the trust and protection of the beneficiary themselves in the long run. So from a trustee perspective, actually, we do take a lot into consideration when we establish a trust in having a dialogue with the settlor in the creation of the trust, having a long-term relationship with them so that we know the changes in family circumstances, differences in jurisdictions where their families may move, anticipate whether there may be a divorce, anticipate if there are children, again, I didn't cover this, from other relationships that may need to be benefited under a trust, looking at the family members who may be moving. And as we know, there is global mobility and trustees do need to be cognizant of this. And particularly now where we have great political and economic uncertainty, clients do need to look at placing their assets in stable jurisdictions, looking at things that they think be unforeseen but do come to reality, again, when we were looking at COVID, and look at the way they plan for their future needs from a succession planning point of view. So at Butterfield, we have offices in a number of jurisdictions. Obviously, I'm talking from the Singapore office. We have an office in Guernsey, in Switzerland, in Cayman, in the Bahamas, and in Guernsey. So we are able to cater to clients' needs for over 80 years in planning for them, holding different asset classes. We have experience in dealing with clients who are from multi-jurisdictions. We've dealt with many, many different types of clients, from those who are business owners, who have inherited wealth, who are entrepreneurial, in catering for those needs and being able to assist those clients in the way that they wish to pass their wealth to future jurisdiction, to their beneficiaries, in looking at many different jurisdictions. So again, if anybody in the audience would wish to have discussions on this, we are very open to talking to any of you in needs that you may have personally or your clients may have, and to work as partners with you in being able to move forward in looking at trust services, because this is something that I firmly believe, having dealt with clients for over 13 years and working for law firms previously and seeing how things can go wrong for clients, setting up a trust and looking to see how you can pass on a wealth of knowledge that you have gained over the years to clients is actually key in being able to assist people in looking at their needs from a point of view for themselves as a client and for their family members. So I think the next session will start in about 5 minutes. So I will stop there, noting that there are no more questions coming through, And thank you very much for your time this afternoon. On behalf of Butterfield, wish you a very good weekend. So thank you very much.